Hello everyone and welcome back to our channel. My name is Anda Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the key characteristics of the adjustment of status on Form I-485. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. When it comes to the avenue through which you are obtaining your green card, there is no one-size-fits-all solution, but the destination is the same, meaning that at the end you will obtain your permanent residence, whether you go through the adjustment of status or through the consular processing. The ultimate result is the same: obtaining the green card physically in your hand. Now, whether you choose to obtain your green card through the adjustment of status or through consular processing really depends on your individual circumstance. And there are certain factors you need to consider when deciding whether you are able to apply for an adjustment of status or it is better to go with consular processing, or maybe consular processing is really your only option. In this video, we are going to speak about the key characteristics for the adjustment of status for Form I-485, which is filed with the United States Citizenship and Immigration Services. Before considering whether to apply for the adjustment of status, you obviously need to have the underlying basis for your green card either pending or approved, and the visa bulletin current, allowing you to actually file the adjustment of status application. And here I refer to the underlying basis: Form I-130 for family-based categories, Form I-140 for employment-based categories, and Form I-526 and I-526E for those applying under the Immigrant Investor Program, the EB-5 program. Now, the key characteristics of the adjustment of status applications are: 1. Convenience. One of the major advantages of an adjustment of status application is the convenience of being able to file it in the United States and have the adjustment adjudicated in the United States without having to travel long distances and deal with the inconvenience of travel expenses and also the entire trip that you need to take and the time that you take in order to travel far distances in order to attend an interview at the US consulate abroad. And this is much more important for those of you who are already living and working in the United States with a work visa, and you have your family members, your spouse and your children here. It is more convenient to file the adjustment of status and be able to continue to work and not disrupt your daily life and children's school while the adjustment of status applications for you and your family are pending with the United States Citizenship and Immigration Services. So definitely convenience for certain of you is one of the most important and major advantage of the adjustment of status application. 2. Interview waivers. The United States Citizenship and Immigration Services has the discretion to waive interviews for adjustment of status applications. And in fact, USCIS generally waives interviews for those that are applying for adjustment of status based on an I-140 employment-based category. Now, the same waivers are at times extended, the same interview waivers are at times extended to those of you who are applying for adjustment with family-based categories, such as the parent or spouse of a U.S. citizen. So in certain situations, USCIS has also extended interview waivers to family-based petitions. Now what this means is that if you obtain an interview waiver, which is solely in the discretion of the United States Citizenship and Immigration Services, then you do not need to attend an in-person interview at the USCIS offices, and instead your adjustment of status applications will be approved based on the documents submitted at the time you applied or anything you answered in a request for further evidence for any documents that were missing. And once USCIS has all the documents required, they can adjudicate and approve the adjustment and mail you the green card, the physical green card, to the address you listed on your adjustment of status application. So you can obtain your physical green card without attending an interview, solely based on your submission with the required documents. And that is the case if you, of course, have an interview waiver, which USCIS officers can choose to grant, and it's solely in their discretion. 3. Work permit and travel document. You and your family members can apply for a work permit, the EAD card, and the travel document, the advance parole application, concurrently with the adjustment of status application or after you have filed the adjustment of status application. Of course, the work permit, if approved, will allow you to work in the United States. Now, certain of you, such as those of you who are in H status in the United States or L status in the United States already working, may not necessarily need to file the work permit with the adjustment of status application, and instead it may be recommended that you continue applying for extensions of your H or L status in order to continue to work under those statuses. Now, if your spouse, however, for example, is in an H4 status or a TD status and they cannot work in the United States, then they may apply for work permit at the time of filing their adjustment of status application. So once they obtain that work permit approval, they can start working in the United States. Of course, again, this, whether you need to apply for a work permit at the time of filing for adjustment of status application or not, depends on your particular circumstance, and you will need to inquire with your immigration attorney to see if you should actually file for a work permit or not, or rely on that work permit to work if you already have status that allows you to work in the United States while your adjustment of status application is pending with the United States Citizenship and Immigration Services. Now, with the travel document, generally speaking, the advance parole document, also known as a travel document, you need to have an approved travel document in order to be traveling internationally while your adjustment of status is pending. So if you don't have a travel document approved and your adjustment of status is pending and you leave the United States, generally your adjustment of status application will be denied for abandonment because you left the country without an approved travel document. So it is important to obtain the travel document while your adjustment of status is pending in order to be able to leave the United States. Otherwise, you cannot leave the United States, or if you leave the United States, then your adjustment of status will be denied without this travel document if you do not have this travel document approved prior to leaving the United States. So that is the general rule. Now also keep in mind that even if you have the travel document approved and you travel with it while your adjustment of status is pending and you travel abroad, that doesn't necessarily mean a CBP officer will, or guarantees that the CBP officer will admit you back into the United States. So keep in mind that there is no guarantee that when you rely on the travel document, a CBP officer will admit you back into the United States. Now, there are certain visa categories that allow you to travel during your adjustment of status application without first obtaining a travel document. So those of you who are working in the United States on an H status or an L status can generally travel in and out of the United States while your adjustment of status is pending without needing an advance parole, a travel document, in order to be able to travel internationally. Now keep in mind both the work permit and the travel document takes some time to obtain. So it is important that you speak with your immigration attorney early on in order to determine whether you should file these applications or you need these applications in the first place, filed together with your adjustment of status application or after you have filed your adjustment of status application, and try to plan a timeline for them if you need them, because the processing times are quite long. 4. AC 21 portability provision for employment-based immigrant visa petitions. So those of you who have an adjustment of status filed based on an approved I-140 petition have the advantage that you can use the AC-21 portability in order to transfer to a new employer in a similar or same occupation after your adjustment of status application has been pending for 180 days or more. So if you have an adjustment of status application filed and pending based on an approved I-140 under the employment-based categories EB1, EB2, and EB3, and your adjustment of status has been pending for 180 days or more, then you can transfer your adjustment to a new employer or the same employer but in a different position. However, in order to be able to port or transfer your adjustment to this new employment, the job offer needs to be in the same or similar occupation as the job offer that was filed for the original adjustment of status application. And of course, your adjustment must have been pending for 180 days or more in order for you to be able to transfer to a new employment situation. Now, if this is the case, you will need to notify the United States Citizenship and Immigration Services and request the portability under the AC-21 portability provision. 5. Less stringent documentary requirements. Another advantage with the adjustment of status is that you do not need to provide police certificates. In the case of consular processing, you are required to provide police certificates for every country where you lived for 1 year or more since you turned 16. And at times, consular officers can also ask you to provide police certificates despite the fact that you lived in that specific country for less than 12 months since you turned 16. Now, with the adjustment of status, you are not required to provide the police certificates. You do have to do the medical examination with the USCIS approved doctor, and you also have to provide any arrest records or criminal records you may have, and attend a biometrics appointment for your fingerprints. But you are not required to obtain the police certificates that you typically need to obtain if you apply for your green card through consular processing. 6. Concurrent filings. Another advantage of the adjustment of status application is that in certain immigrant visa categories, you may be able to file the immigrant petition, the I-130 or I-140 petition or I-526 or I-526E concurrently with the adjustment of status application and the work permit and the travel document. But this depends on the immigrant visa category and also on the visa bulletin if your category is current under the visa bulletin. In the case of family-based petitions, specifically for immediate relatives of U.S. citizens where immigrant visas are always available, there you will be able to file your I-130 in that specific category concurrently with the adjustment and the travel document and the advance parole. And in the employment-based categories is typically the I-140 based on an EB1 category that is typically current, and in that case you will be able to file your adjustment of status application concurrently with filing form I-140. And the same applies for those of you who are applying under the EB5 immigrant visa program, but you need again to check with the visa bulletin and see if in that category under your country of chargeability you will actually be able to file the adjustment concurrently with your underlying immigrant petition. Generally, it is not recommended that for every employment-based category you apply for adjustment of status. So it is important that you speak to your immigration attorney to see if you can actually file the adjustment of status concurrently with your underlying petition, or if it's even recommended to do that, or is better to go through the consular processing. And finally, 7, processing times. The processing times for the adjustment of status are typically very long and much longer than the processing times for consular processing. You can expect in certain family-based categories such as the immediate relative of a U.S. citizen and the EB1 category in employment-based petitions, the processing times can vary from 6 to 12 months. But for the other category in the EB2, EB3 petitions, you can expect much longer processing times. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.